ษณา Okay. Good evening. Welcome to the Foreign Correspondents Club of Thailand. My name is Phil Robertson. I'm a member of the board of directors here and the director of the Asia Human Rights and Labor Advocates. Thank you very much for coming out on a Monday. I know it's a little bit difficult to get here. The Red Cross Fair is in Lumpini, so it caused some massive traffic. I went past it on a motorcycle taxi, and I'm glad I wasn't in a taxi. In any case, tonight we're going to be talking about transnational repression, and particularly the case of Montagnard human rights activist and leader Qing Bdap. Many people may have heard about the case, but let me just say a few words before we get into the panel. Qing Bdap, Montagnard leader, refugee, recognized by UNHCR, came to Thailand, was seeking third country resettlement with wife and children here, was arrested, and the Vietnam government had convicted him of terrorist-related crimes in a court proceeding that was neither free nor fair, and ultimately sentenced him to 10 years in absentia. And there then kicked off an event between Thailand and Vietnam related to the possible extradition of Qing Bdap. Now, we call this an issue of transnational repression because he was sent back and he was a refugee. It's a case of refoulement. It's very clear also that Vietnam worked very, very hard to persuade the Thai government to send him back. We had thought that transnational repression might be a thing of a past when there was a new civilian elected government. There was, for many years, under the Prayut Prawit military government, transnational repression that was taking place, sending people back to China, including the Uyghurs, to Vietnam, to Cambodia, and other places. But when the new civilian government took over, there were undertakings made to some of the people in the NGO world that, that was then, this is now, we're not going to do these kind of things. And unfortunately, it's happened again. So Qing Bdap right now, we believe he's been sent back to Vietnam. In fact, there's been no confirmation of exactly where he is, and some of our speakers will get into that. The decision to send him back actually was a striking setback for human rights activists and those seeking to combat transnational repression between Thailand and authoritarian neighbors. And equally important, it was a failure by Thailand to uphold the Prevention and Suppression of Torture and Enforced Disappearance Act, which was passed in 2022 with much fanfare and international praise from the UN and from international human rights groups and others for that law. Article 13 of that law, which is in effect in Thailand, explicitly prohibits Thai officials from acting, quote, to expel, deport, or extradite a person to another country where there are substantial grounds for believing that the person would be in danger of torture, cruel, inhuman, and degrading treatment, or enforced disappearance. And if you know anything about the way that Vietnam has treated the Montagnards in the highlands in Vietnam, you will know that torture is just the start of it. So we've assembled a panel of distinguished speakers to talk about this case and talk about the wider issue of transnational repression. We wanted to have a representative from the Thai government. Unfortunately, that didn't happen. We just got no response. And I think no one is really terribly surprised by that. So today we're gonna hear from 4 speakers. I'm gonna introduce each one before they speak. At the end of the evening, we'll have an opportunity for question and answer. Our first speaker is Prakai Dao Pruksa Kem Samsuk. She's the Deputy Director at the Cross Cultural Foundation. Together with her family, Prakaidao, or Tien as she's known, has been advocating for democracy and freedom of expression ever since she was a student. She started working with the human rights community in 2021 when she began her job at CRCF as a project coordinator, and she manages various different projects for them. Very importantly, she's also an expert on the issue of enforced disappearance. And she's going to kick off tonight's discussion. So let me turn the floor to you. And make sure you speak into the mic, yeah.
Okay. Hi, good evening, everyone. My name is Thien Bdap, and I am a Deputy Director from Cross Cultural Foundation, Thailand. So we are a human rights organization based in Bangkok, and we are working to address the issues of state violence, including torture, ill treatment, enforced disappearance, and one of the most serious threats that we are going to discuss today, the transnational repression. So my discussion will focus on the wider situation about TNR, transnational repression, in our region, and also the legal landscape right here in Thailand. So in Thailand, 2 years ago, we have taken an important step towards protecting human dignity. And I'm talking about what Phil also already mentioned about the Prevention and Suppression of Torture and Enforced Disappearance Act. But after 2 years of the enactment, we are still keeping to see cases of torture, enforced disappearance, and transnational repression. So the case of Mr. Bdap is part of a growing patterns where at least 38 governments have engaged in acts of transnational repression in over 91 host countries, according to the Freedom House report. And our Southeast Asian countries are not excluded and may be one of the regions that practice these tactics the most systematically. The targets are consistently human rights defenders, journalists, political opponents, and minority ethnic and religious groups such as Mr. Bdap. And I'm about to give you some specific examples of other nationals who have faced similar tactics of TNR and forced return in Thailand. So these are the cases that CRCF and our network CSOs provided legal assistance or has been reported. The Cambodian community, so the first one back in December 2024, 7 Cambodian refugees in Thailand, among them one was just a kid, were unlawfully deported back to Cambodia, where they were summarily detained, and we are no longer unable to learn more about their fate. There is also another threat to the Cambodian when we have a voice recording of Hun Sen leaked, and it shows how he just ordered someone and talking to his secretary, Kliang Huat, to kill the dissident abroad. So the targeted person back then was Pornpanna. Another case, very scandalous, Mr. Lim Kim Ya, Cambodian government opponent, who was shot right in the middle of the city of Bangkok in the middle of this year. So in this case, even though the Thai shooter was convicted, but we are still unable to trace further and hold accountable those who order or sponsor such killing. So we have the names and the face of relevant involved persons, Cambodian person, but then due to the legal jurisdiction, we cannot go further than just a hired shooter. And next, we have the case of 48 Uyghurs earlier this year as well. So this case, despite international warnings, the Thai authorities forcibly deported them to China in February. This forced return was widely condemned by the UN bodies, human rights organizations, and several Western governments. And then we also have the Thai nationals case. So after the coup d'etat in 2014, at least 9 Thai dissidents in exile in neighboring countries, including Vietnam, Laos, and Cambodia, were abducted or assassinated. The names are DJ Sun Ho, Koti, Surachai, Gaidet, and Chachan. The 2 latter were founded in Mekong River. Siam, Chu Chi, Grisana, and Wanchalerm Saksit. And then for our Vietnamese community, we have been reported of systematic harassment of this community, including Thai and Vietnamese officials monitoring and speaking with the refugee groups in their community, in their villages, or visiting them in IDC cells. This also includes a form of mass arrests or targeted arrest for illegal entry in an attempt to forcibly deport them through the IDC channel. And in all these cases, most of the time the UNHCR status are not considered by the Thai authorities. They are also exposed to a certain form of extortion by the police when they are arrested. So this is a very concerning situation for the Vietnamese refugees. The community is also at risk of enforced disappearance, such as the case of Duong Wan Thai in 2023 and Mr. Chuang Dui Yat in 2019, where they are abducted from Thai soil and reappear again in Vietnam. However, since Thailand we have the anti-torture law, we are now seeing the countries of origin using the method of submitting extradition requests for the court to consider and issue an order instead. So they use the Immigration Act, the Extradition Act, as the basis to claim legitimacy for the forced return, without regard for Section 13, as also explained by Phil, that prevent refoulement. So this is what happened to the case of Qing Bdap, and Natalie will also talk in details later. So I would like to talk about another, in details about the law. So there is a big gap between the law and reality, actually. So we have the anti-torture law, but the will to utilize them to protect the refugee communities, or even for Thai nationals ourselves, remain very challenging. So the Anti-Torture Act, as the name, it explicitly criminalizes torture and enforced disappearance, and serves as a crucial legal protection mechanism. Another core component, the non-refoulement principle provided by Article 13. Again, this principle prohibits the forced return of any person to a place where there are substantial grounds for believing they would be in danger of torture or enforced disappearance. So as a civil society organization, CRCF, our work in Thailand is often about seeking accountability for state violence, including against the foreign nationals who are targeted by TNR in Thailand as well. However, with almost all the cases that I have mentioned earlier, we use the Article 29 of this Act, which gives us the right to notify act of torture or enforced disappearance to relevant authorities to try to intervene the deportation, especially to the administrative officials and also the public prosecutors. They are responsible to supervise any arrests, but yet the common reply we get from them would be that they check the process and that everything is fine, is lawful, and the intervention by these authorities was never made. As I said, that many people are deported back to the origin country already. And also the fate of the deportees was never investigated or revealed to us or the families. In the case of Uyghurs, we also use Article 26 of this Act to file with the local court a petition for an order mandating instant termination of their deportation. But within that day, the court ordered that we are not the person of interest of the injured person, even though the intention of this law is to allow the witness or human rights organization to help reporting these crimes. So the petition was dismissed. In terms of the violation of Article 13, in the forced return of refugees, activists, and including the case that brings us here today, is the direct contravention of the intent of this new law, demonstrating a gap between legal commitments and state action. So to seek accountability for the violation of this specific article. This year we filed over 38 petitions to relevant authorities, including the Right and Liberty Protection Department, Ministry of Justice, as they are the National Committee to supervise the law. The Center for the Prevention of Torture and Enforced Disappearance of the Attorney General, the Government Cabinet, the National Human Rights Commission, the Immigration Bureau, the parliamentarian committees, and so on. So all in all, we received only the reply letter stating something like they are investigating, they found no act of torture along the process, and that the arrest process is lawful and well notified. But we have never been shown any evidence that the deportation was voluntary and respected human rights standards. Except there is that one time when they sent back the Uyghurs, and then all the whole ministers, big guy, went to the China to prove that they are just fine, not tortured. And finally, and most importantly, no official involved in the deportation or extradition process is held accountable as of today for their violations of the Article 13, as well as the horrible verdict of the court in the Mr. Bdap case. So that's why we are still feeling that TNR will keep happening and that the act will be just a paper tiger. So I will end my discussion here and then back to Phil. Thank you.
Thank you very much. Next, we're going to hear from Qing Bdap's lawyer, not the city Bergman. Let me just explain who she is. She's a human rights lawyer. She's the founder of Phoenix Justice Law Office. She was also the former president of the Human Rights Lawyers Association and has a lot of experience in extradition, immigration, protecting refugees and human rights defenders. People may remember that she was very involved as the lawyer to Hakim Al-Arabi, who was the Bahrain football player who, during the military government here, the Thai government was trying to send back to Bahrain, ultimately unsuccessfully. She led the legal team in the Qing Bdap extradition case, working on the principle of Thailand's non-refoulement obligations and the risks he faces if he returns to Vietnam, and he has been returned to Vietnam. I think we can say that she got very little notice of the appeals process, which was quite unusual. Most of us expected the Qing Bdap's case would come up sometime the first or second quarter of 2026. In fact, it was brought up very quickly, and as soon as the case was completed, he was taken out. So we're going to hear from her, her perspectives on the case, what happened, and what this means for other cases like this.
Thank you, Khun Phil. Yes, my name is Natha Siri Bergman, or my friends call me Natalie. I am graduated from Cross Cultural Foundation. 2014, I was working on anti-torture in the Deep South, and then I worked on there for 3 days on anti-torture, anti-enforced disappearance. The first case I was have to deal with was, as soon as I get the job, I have to fly down to Narathiwat and trying to find somebody. And then after 4 years of that, I work as the director of Human Rights Lawyers Association, still involved very much. And now, my heart is still in the human rights world, and I feel like there's a lot of challenging is going on, and I want the judge to see the law as we see it, and this is why I still get involved. So for the transnational repression that we are working on, not only that we see Qing Bdap. Qing Bdap is a soft case. I'm sorry to say this, but we see extrajudicial killing for Lim Kim Ya. I represent the family, and then in that case from the beginning, there's a lot of discrepancy going on when there is a guy who confesses to have committed the assassination act, and then the police said, since we already know who did it, we are not going to dig into what is the intention or what is going on behind the scene, why is this guy assassinated, even though we have a lot of documented and record saying why this person was targeted. And that is one of the example. And then we have extrajudicial on top of extrajudicial killing, we have extrajudicial extradition. It means abduction. You know, there is a cooperation going on between the Southeast Asia country. You will see that refugee is disappear from their home and then all of a sudden appear in the prison in the original country, or the guy who is already planning to go to another country and disappear, and the government come out and deny of having anything to do with it. So Qing Bdap is, I said, is the soft case because at least we know what's going on for a brief period of time until we are trying to defend the case and saying that even though there is this legal, because my government trying to prove that we are civilized and we have law and we respecting all the law. So we are not going to summarize and extradite anybody. We have the procedure that we have to follow through. But in Qing Bdap case, from the beginning, even before he was arrested, we know that he already been followed by the Vietnamese authorities. Why we know that? Because we working close to him, and that later on the Vietnamese police testify in court and then say he was the one followed and then notify the Thai immigration police of the movement of the person, and then he have to relocate 3 times before the warrant of arrest was issued. That is even before. And then when he was arrested, he notified the police who arrest him in the beginning that he has the refugee status. He got the status from UNHCR. And what the police trying to do to say that we're respecting the law is we are wearing the body cam to show that we are not torture or we are not doing anything illegal. But that is totally contradicting in the court procedure. Entering into every case that I am working on in the extradition, the prosecutor will make an objection for any bail that we are trying to make a request as a high risk. So they will have to be in detention, Bangkok remand. And you know, when a person is in the remand center, very difficult to prepare any cases, especially if you are not using Thai language. I was limited to speak 20 minutes per visit to my client when I cannot speak Vietnamese, and then I have to use a translator. Imagine that I have to get all the facts down. And that one of the, even before the case is started. Now, when the case is started, it's rooted from, because Thailand was not signatory to the refugee, we are not ratifying that, and we are following our own law. And because the law that is being using against all the refugee or asylum seekers, Immigration Act. The Immigration Act is falling under the Security Act, which means they give a lot of discretion to the police. The police can see you as a threat to the national, and you do not know. You might act something weird, or you might have a case against you in your original country, or you know, you're being suspicious of committing whatever, and then they can revoke your visa. It's so bad against the person of concern that they wanted. They can charge you with not staying at the location that you report on your TM30. I mean, a lot of our friends here, you know, are very well aware of what TM30. The foreigner have to disclose where they are staying all the time. But when you want it, you know, if you did not disclose if you did not support your TM30, they can charge you with that to begin with. Not because the fine for that is very, very low, but it's not because they want to punish you, because they want to comprehend you. And so for the asylum seeker, for the refugee, there is no protection. Now, when we enter into the Extradition Act, when they be able to hold you in custody already, the Extradition Act is very straightforward, very easy. It's kind of like checkbox all of the cases that I'm working on. if there is a request going through the Foreign Affairs, going to the Ministry of Justice, there is a request translation, and then they check, and go, boom, okay, these cases can do extradite. Even though for the Extradition Act, section Article 9 saying that if there is a law in your country prohibited of extradite, or if there is a political cases, then you cannot be extradited, or there is a the action that is so unfair, then the person might not be treated fairly in the case, then you cannot be extradited. Those are three clauses that we are using in the Qing Bdap cases, and is sadly it was not considered. The court from the first case saying there already enough qualified document, and that is submitted and going through the channel, and that is already as a base for the judge to make a extradition. As for there is no law to extradite, to prevent, even the law is preventing the extradite, the judge see it as the judge is not part of the government official. The judge is independent, independent organization. Government official will be the police, the soldier, they're distancing themselves from that. And then for the political cases, we are trying to submit the document to the court saying that Montagnard people have been discriminated against, they're treated badly, especially if you are leader of the church teaching and the house church, and then with the history of Bdap, have the history of repeated arrest and torture, and the judge go so far as to explain that in the judgment that you do not have the evidence, but to prove that you were tortured in prison or under custody. How can a person, being tortured under the custody of the police in their hometown, run away to Thailand, have any evidence? They don't even have document, So it's of great disappointed that even though we are trying to explain to the judge, we do not, our argument is not perceived and not to see as we are wanted as to the government to see. Now, another cases that I'm working on is not directly, there is a report of that person being tortured during the interrogation with the evidence that he was tortured during the interrogation. The judge in the extradition case said those are case specific. Because it happened in that case doesn't mean it's going to happen in this case. This is why all of the independent opinion from the expert against anti-torture, for the working group on the anti-torture, anti-enforced disappearance, not even consider, never mentioned. Even all of the report, that been putting out there how Montagnard people be treated, how the condition in the prison, how bad it is, it never considered in that. So we did everything that we can, but unfortunately, the judge is still seeing how to interpreting the law differently from us. Now, this case moving forward very quick. Usually it will be minimum of 2 years. This case is 6 months. 6 months since the day we submitted the appeal on April 16. The prosecutor submitted the response to our appeal May 16. And then within less than 6 months, we have already have the judgment from the appeal court. I have got the phone call. Usually in normal setting, the clerk will send me a notification saying that your case will be read at this court on this date. Will give me a heads up. It's about 1 month in advance. This one, they called me on 24th of November and said, tomorrow the court will read the judgment, and said, we are not available. 3 of the lawyers working on the case is not available. Can you move forward? The clerk said the procedure have to be happen in front of the defendant, not the lawyer. So they have the lawyer, they arrange for the defendants, for Bdap, they arrange for the translator, and that's enough. Whether or not the lawyer will be present, it doesn't matter. So the next day, they read it anyway, on the 25th of November. And as I mentioned, the judgment was very bad and very disappointed. We still have hope because the Prime Minister still have the discretion because he has the authority to, if you are going to protect the right of the person, you do not need judicial review. So in another case, there's also when the appeal court said that the case can be extradited, the Prime Minister can say with his discretion, he will not extradite. I submit that letter to the Prime Minister on 26th of November. 27, he was moved from Bangkok remand prison to the Qing Bdap prison. And that was the last time anybody ever see him. 28th of November, the correction department publishing the public statement saying that he was already transferred to immigration for the process of extradition. So on the 29th, I went to the immigration at Suan Phu because to send anybody away to the third country or whatever, they have to do the exit, exit clearing. I cannot, what is that? The
Yeah.
They have to do
you
the
have to clear your
exit
documents.
formality that you need to give us where are they going, what flight, and how are they going to what. Now, by law, they have to do between sunrise to sunset. And when I went there at 9 a.m. on 29, they said he was not in the custody anymore. This is why I think he been already sent since 28th of November. So I submitted the request also for the standing committee of the what you call
The Ratha Sabha, the parliament.
the government, and we wanted the immigration police to come and give us the answer of when was he sent back and what flight and what airport, because one of the police from Vietnam testified that he will be at the specific prison. But since 28 until now, his family have been try to locate him. They said he's not there. So we do not know where he is right now. And since the parliament already been resolved, so I think the parliament is not here, but the Senate is here. Even though I do not have much hope in the Senate, I hope still we have to do something. So the last thing that we can do is we will request for the standing committee at the Senate for the human rights to ask the immigration police to please disclose to us when did you send him back and what flight. At least we know, or if he not been sending back to Vietnam, tell us where he is located right now. So that is for me. There's not like as much as we want to know, if we also have very much restraint that we cannot just go down and trying to see it for ourselves. But if you have any other question,
It is rather astonishing that his lawyer and the people who were working with him can't even get the information about like how he was sent back out of the country, regardless of the fact that the court decided that it wasn't going to rule on the substance of the law and was going to allow him to go back, despite the fact that many people said that in fact if he was sent back he would be tortured. And it was quite clear, I think, that we also had Vietnamese officials in the courtroom. We had Vietnamese officials talking in advance of the case with the prosecutor's office. So this was very much of a stitch-up between the Vietnamese government and the Thai government. And now lawyers can't even find out where he is, how he was sent back. when exactly he was sent back, by what flight. So, I mean, it's a very disturbing situation. It calls into question the whole issue of international standards, since this person was, in fact, a refugee, was recognized by UNHCR, was entitled to some protections, and obviously did not get those. And so we're going to hear a little bit more about the international standards. We're very privileged to have Cynthia Velico with us here. She's the head of the Asia Pacific region here, Southeast Asia, for OHCHR, the Office of High Commissioner of Human Rights. She's been a human rights advisor in a number of different countries, in Pakistan and Sri Lanka and the Philippines, and her official title is Representative of the Regional Office of the Southeast Asia. She's been working here for a number of years, really covering the gamut of issues across Southeast Asia, which is a very challenging mandate given the amount of problems that happen here on human rights issues. And we're very lucky to have her come to speak with us on what is a very busy week for her and others. So, Cynthia, please go right ahead.
Thank you, Phil, and good evening, everyone. Swadika. As we have been discussing amongst us now, there is clearly over the past years been an evolving human rights situation and challenge that we are seeing actually both globally as well as in this region that really, we could say, strikes at the heart of human dignity and the sovereign state's fundamental responsibilities to protect, and that is the phenomenon of transnational repression. This threat manifests as states extend their reach beyond borders to silence, intimidate, and persecute dissidents, human rights defenders, and political opponents who have actually sought safety abroad. This growing practice threatens the very principles of sovereignty, the rule of law, and international human rights framework upon which our shared commitments have been made. Over recent years, patterns of transnational repression have become increasingly concerning, and this was discussed by a number of the panelists. States are employing a range of tactics that are actually deeply disconcerting. Surveillance and intimidation that extends into host countries, coercive diplomatic pressure on neighboring governments, and we've heard a little bit about that in Mr. Bdap's case, arbitrary detention and enforced disappearance, and at times extrajudicial action that targets refugees and asylum seekers beyond their borders. Technological advancements, including cyber surveillance and digital tracking, have augmented the capacity of governments to reach victims globally. We've seen this, of course, even in European countries where there has been state reach way beyond this region and into others to pick up people who are of concern to governments. The impact is both individual as well as collective, and it undermines the safety and protection of those who have fled persecution, sowing fear within diaspora communities that we see very tangibly here, and a very chilling, legitimate, and very much chilling legitimate dissent. These acts don't occur in a vacuum, and they challenge the core values that are enshrined in international human rights law, particularly the principles and protections that guarantees refuge for those that are escaping persecution. The International Covenant on Civil and Political Rights affirms the inherent dignity and equality for all persons, irrespective of their nationality, their migration, or their legal status. Equally, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, as well as the International Convention for the Protection of All Persons Against Enforced Disappearance, all three of which impose strict obligations on states to prevent torture, enforced disappearance, and other related abuses that we see taking place, and under all circumstances. All states in Southeast Asia, it's important to know, with the exception of Malaysia, Brunei Darussalam, and Singapore, are state parties to the ICCPR and to CAT. Thailand and Cambodia, in addition, are also states parties to the International Convention Against Enforced Disappearances. So when you're looking at those three legal instruments, there are very binding legal commitments that are required to be upheld with regard to things such as refoulement. And foremost, then, amongst those obligations is the principle of non-refoulement, which is an absolute prohibition against returning any individual to a territory where they face a real risk of torture, cruel treatment, or persecution. This principle is not merely a moral imperative, but it's a binding legal norm of customary international law. That's important because many states will say that they have not actually ratified some of these treaties, but it's binding under customary international law, and forms the foundation to the legitimacy of human rights, law, and order more broadly. States must ensure that no person seeking protection finds themselves forcibly returned to danger under any guise, including through indirect or informal arrangements that circumvent legal safeguards. Moreover, states have an affirmative duty to protect refugees and asylum seekers from acts of transnational repression that is occurring within their jurisdiction. This responsibility entails providing effective remedies and protections against harassment, surveillance, or harm by foreign agents, and that's something that we certainly have seen over the years here in Thailand. It also requires robust cooperation with regional and international mechanisms to investigate violations that have taken place and to hold perpetrators to account. With regard to individuals that are facing allegations of terrorism, and this is quite important because it speaks to Mr. Bdap's case, if they are facing these allegations of terrorism in their countries of origin, the United Nations human rights mechanisms have very clearly affirmed that the principle of non-refoulement under Article 3 of the Convention Against Torture remains absolute, prohibiting expulsion or extradition of individuals where substantial grounds exist for believing that they risk torture. The UN Special Rapporteur on Torture has emphasized that diplomatic assurances from receiving states do not mitigate torture risks. Another important point, because we hear many states saying that they can provide these assurances if they are extradited. States must scrupulously assess all relevant factors, including patterns of repeated and/or gross human rights violations, without exceptions, for security concerns or terrorism suspicions. Mandate holders from the special procedures reject any derogation from non-refoulement in terrorism contexts, noting that after 9/11, increases in refoulement despite known torture risks, and caution that assurances lack enforceability and/or post-return monitoring efficacy. The UN Committee Against Torture echoes this, requiring that real and foreseeable personal risk evaluations beyond mere suspicion are applicable regardless of those allegations of terrorism. General Comment 4 of the Convention Against Torture reinforces that non-refoulement applies without exception for terrorism suspects, and it requires an assessment of foreseeable, real, and personal torture risks from state or non-state actors, considering factors like ethnicity, political affiliation, and receiving states' human rights records. That means an assessment of whether the risks of torture or abuse are real. The committee deems diplomatic assurances unreliable and mandates that no balancing of security interests against torture prohibitions can be deemed credible. It's important to note that multiple special procedures communications have been sent to both Thailand and Vietnam on this case, outlining their legal obligations as well as a host of human rights concerns related to the risk of refoulement. This is important for what Natalie had said, which is that in the judgment, there was indication that there was not sufficient evidence produced on those risks. In addition, an amicus curiae brief by the Special Rapporteur on Counterterrorism and Human Rights was provided specifically on Mr. Bdap's case to the first instance court that articulated very specific legal obligations and requirements when dealing with cases of extradition for individuals that have been charged with terrorism. On the broader trend of transnational repression in the region, here in Southeast Asia, the Special Procedures Mandate holders have sent over 15 joint communications since 2017 on cases of transnational repression, including a most recent communication that went to ASEAN. The dangers of ignoring these duties are profound, and failure to uphold non-refoulement and protection standards erodes trust in states. It emboldens states to extend their repression transnationally and destabilizes the fragile balance of peace and respect amongst neighboring countries. The use of transnational repression undermines the credibility of legal commitments that are made by states, both domestically as well as internationally. And it also undermines the respect and moral leadership to uphold core principles of dignity, protection, and the rule of law. States are required to protect the rights of all persons within and beyond their borders, and it is a commitment that must be reestablished with urgency in this region and an unwavering resolve by all states, including globally, to stop the refoulement of individuals that are at risk, at grave risk of human rights violations should they be returned. Thank you.
Thank you very much, Cynthia. I would note that as I was listening to this, I was thinking about the fact that I understood that like the Vietnamese government had sent a letter to the prosecutor saying, oh yeah, we won't torture him if we take him back. And that was this considered to be some important piece of evidence by the Thai court and the Thai government. But in fact, the international special rapporteurs and others basically say that's not something you can really sort of depend on.
No.
And unfortunately, I think that we're facing a very difficult situation with that kind of assurances being made and being accepted at face value here by the Thai authorities. Finally, we have the pleasure to hear from Sanhawan Sisot, who's nicknamed Kay. She's a senior legal advisor to the International Committee of Jurists here in Bangkok. And she leads and implements ICJ's work in Thailand and across Southeast Asia, does an incredible amount of work on various different issues, including civil and political rights, gender equality, business and human rights, access to justice, and coordinates a lot of work about legal analysis, court submissions, and reports to UN human rights mechanisms. Importantly, she's also a member of Thailand's National Subcommittee on Law Development for the Prevention and Suppression of Torture and Enforced Disappearances Act, which is a committee that was set up by that act when it was established. And she sits on several parliamentary subcommittees in the House and the Senate, or at least did until it was dissolved just yesterday. So she's got an insider view of what we're looking at here. It's interesting that this Thai law on prevention and suppression of torture and enforced disappearance, and there's been multiple submissions to it, to the authorities about that law, but very few actual cases have come out. So I expect she'll probably tell us some more things about that in addition to the actual law itself. So over to you.
Hi, thank you. Thank you so much, and good evening, everyone. I'm Kay, San Hawan from International Commission of Jurists. So my presentation indeed is trying to link the presentation made by Natalie as well about Thai law, and also what Cynthia has been mentioned, international human rights law, like comparing what's the gap that now exists under Thai law and has been reflected in Bdap cases, in the judgment itself, and what should be the next step, what should we do moving forward in terms of addressing this gap under the law. So currently, if we look into the key legal framework in Thailand that mentions something similar as the non-refoulement principle, there are 2 laws and 1 regulations. The first one is the Extradition Act, in which Natalie mentioned, but I I just copy and paste the law, the translation of the law themselves here, so you could see how it looks like. So Section 9 basically say that extradition can happen as long as subparagraph 1, if it the offense that could be extradited and not prohibited by Thai law, and not the offense of political characters and military offenses. Oops, how did I move it? Okay. The second law that talk about this is the Anti-Torture and Enforced Discipline Act, in which Natalie also mentioned. Section 13 basically say that no one shall be expelled, deported, or extradited if there are substantial grounds for believing that that person would be in danger for torture, cruel, inhuman, degrading treatment, and enforced disappearance. So if you see the language, it uses the term substantial grounds to establish it that there could be the risks. It's not like you have to prove that 100% is going to happen. You know. Oh, and very quickly on this point is that indeed we almost doesn't have this provision of the law within the Anti-Torture and Enforced Discipline Act, because in every version of the draft law that has been handed to the parliament in the past, that has been drafted by the government, they will remove this article. And the justification, and sometimes even at the parliament they try to remove it, like till last minute. And one of the justification was exactly what Cynthia mentioned. They say that Thailand was already bound by customary international law, so we're not going to deport or extradite anyone at risk who are at risk for being persecuted in their home country. But as you can see, even we have the law now, you know, extradition still happen. And lastly is regulations. This is quite a new regulation that has just been adopted in 2019 and entered into force not just a few years ago. It's called the Regulation of the Office of the Prime Minister on Screening Alien, who is a very long name, but in short we call it NSM, on National Screening Mechanisms. But we have to highlight that it is only a regulation, so it doesn't have a stronger legal force compared to a law, not like Anti-Torture or Extradition Act. But under these regulations, it basically say that while enforcing immigration law, the officer cannot send anyone back, deport or extradite anyone if there's a reasonable ground to believe that that person might be a protected person. The term protected person has been used by Thailand instead of refugee deliberately under this regulation. And protected person has been defined under this regulation as someone who has reasonable ground to believe that they would be in danger due to persecution as determined by the committee. Indeed, the definition of this act is kind of narrower than international refugee law, because it depends on whether the committee will think that that person could be refugees or not. But it considered kind of like another tool and the new innovation by Thailand to address the issue of refugees, try to provide protections for the refugees. So what the problems that we have here is that Bdap case has taste of these law and regulations. Like the judgment in Bdap case mentioned the two law, one regulation, and try to explain how they could be interpreted in the view of the judges who's working the case. Several interesting things that we found based on these law and regulations that has been mentioned in the judgment, several of which Natalie already mentioned. The first one is that the Thai court in the judgment, they say that they're not gonna examine how the foreign judgment was reached, like whether it was lawful, like the investigation was lawful or not, how the judicial procedure was carried out or the trial standard was carried out. Just focus on the offense, whether this is the extraditable offense or not, because that's how the law wrote. If you look into the, just have to go back and say, because the extradition law in subparagraph 1 just say where it is an extraditable offense. It didn't say where it is like a extraditable process or something like that. So that's why that how the court try to explain why they not gonna, why they disregard the problem of a fair trial, basically. And the second issue that has been come up is that the court kind of say that, which is linked to the both issues, that the court ruled that the case was not political because it is a terrorism offense. It's not the same, it's a different name. Terrorism and political offense. The third one, the court insists that there is no explicit provision in Thai law stating that UNHCR-recognized refugee cannot be extradited. They really say that in the judgment. And also emphasis that the NSM regulations cannot override the Extradition Act. So NSM regulation was this one. Sorry, I mixed this up. This one dimension that talk about protected persons, you know, and the court say, okay, even if you think he's the protected person, but this is just a regulation. So I just focus on Extradition Act. Basically, that's what happened. Next, another issue is that the court found no reasonable ground to believe that he would face torture, ill treatment, or enforced disappearance by relying heavily on diplomatic assurance. So when the court look at whether there could be such a reasonable ground or not, the court say, oh, they shouldn't because we got diplomatic assurance. We got the assurance from Vietnam that he'll be okay. And lastly, the diplomatic assurance were considered more credible by the court than reports by domestic and international human rights organizations, including the UN report as well. So once we see the judgment, then we start to think about, okay, so what should be the next step? Because the judgment itself also revealed the gaps and the problem within Thai law. So there are two big gaps that I identify, and I will just talk about it at the same time as trying to shape the recommendations for next step. So one way to address the issue is, okay, first, because judges will always rely on legal framework, will always rely on the law. So Thai law should also be either amended or interpreted in a manner that in line with international law and standard. So what can we do? The first one, which is very important, but pretty not very easy to do because we have tried to push for it for like decades, but didn't get a lot of support from the Thai government, which is to make an explicit recognition of non-refoulement principle within the law itself. Like the law should talk about non-refoulement that go beyond Article 13 of Anti-Torture and Enforced Disappearance Act and go beyond political grounds. Because if you look at international law and standard, the non-refoulement principle are broader. It's not, of course, it's about, it's not just about those who are at risk of torture and for disappearance, ill treatment, but it should also protect those who have welfare prosecution based on other grounds, political opinion, race, religions, a member of a particular groups. If they face a welfare prosecution, upon return they should be protected and shouldn't be deported. So this language should be explicit within the law. It could be by amending Extradition Act, incorporate, you know, this principle within the Extradition Act. Another way is evaluating the NSM regulations to an act. So it has like a stronger legal force, but the regulation itself should also address some existing gaps. And lastly, amending Immigration Act. Immigration Act is basically the act that gives the power to just send people back as well, apart from Extradition Act. So that's another way to try to include the principle of non-refoulement. The second one is a little bit less complicated, more doable, more like low-hanging fruit, which is to align Section 13 of Anti-Torture Act with international standard. But this one is not enough. Like, I think we have to do both. First, we have to expand the idea of non-refoulement under Thai law. But second one, the existing framework we have, we should improve the interpretations of it. The first problem is the term substantial grounds, reasonable ground, whatever, that they wrote in the law. Article 13 says if there's substantial ground to believe that there's going to be like torture, ill treatment. These people shouldn't be sent back. And Cynthia already explained that this substantial ground means foreseeable personal prejudice under international law. I'll just say in short, under international law, whether they're going to be substantial grounds under international law and standard, whether they're going to be substantial ground or not, we look into first personal risks, second pattern of gross and flagrant and mass violation of human rights, and third whether they're going to be that there are preventive measures in the country of destination or not. And these elements must be clearly established. Just explain more about each these elements. When it comes to personal risks, the UN Committee Against Torture, Cynthia touched upon some of the examples, but they made it clear that indeed there's a long list of personal risks that the court, the authority should look at when they try to estimate whether there are substantial ground to believe that that person could be tortured or ill-treated or not. And this expand beyond the previous torture, which in G. It also includes, as you could see, ethnic background, political affiliations, arrest, detention, trial in absentia, sentence in absentia, sexual orientation. It could be like, there's a long list of it in which the court should look at. But in the case of Bdap, as you heard from Natalie, the court just looked at one element, which was the previous torture. And the way they look at it is a bit problematic as well. Apart from that, the UN committee also made it clear, like apart from personal leaks, how the authorities should also examine the human rights situation in the destination state. In paragraph 46, we not have time to go through detail on that. And very quickly, also on diplomatic assurance, because the UN Committee Against Torture touch upon that. Cynthia already mentioned, but I'll just put them in written for you here. They say pretty clearly that the committee consider that diplomatic assurance, such as this case, from a state party to which a person is to be deported, should not be used as a loophole to undermine the principle of non-refoulement. So if there's a risk that these people could be subject to prosecution, to risk of torture, ill treatment, such diplomatic assurance shouldn't be used to justify the deportation or extraditions. So, this is my last one. Yeah. Oh, sorry. Yeah. So what happened in this case is that the court focused on past torture, as you heard, but they apply excessively high and subjective evidentiary threshold against the term reasonable ground, but the court wants the evidence, and also disregard victim's own account about their past torture evidence. Indeed, it's not like there's no evidence. The victim themselves provide a testimony that he was a victim of an act of torture, but that part was totally disregarded within the judgment. Another thing that has been disregarded was also other personal risks apart from his past torture experience, like sentencing in absentia, his ethnic background, political activities. The pattern of systematic human rights violation in the destination state has also been disregarded. The lack of effective safeguard against torture in the destination state has also been disregarded. And the fact that diplomatic assurance cannot be used to bypass, like as a loophole against the non-refoulement principle, has also been disregarded. So one way is that these issues should either, if it can't be in the law themselves, it should be in the SOP, the standard of procedures, it should be in the guideline for the authorities who are working on that. And frankly, it's not like no one know about it, because in the once not so long ago, after the situation with Uyghur in the subcommittee on law under the Anti-Torture and for Discipline Act, there was a question from the National Human Rights Commission in Thailand about, they asked the subcommittee how should we interpret Article 13, like what international law say about this. And the committee kind of prepare something like that, like copy and paste what the UN Committee Against Torture say and send it back to the NHRCT, the National Human Rights Commission of Thailand. But that knowledge has been limited only amongst the committee members and the NHRCT, but it hasn't been sent, it hasn't been shared, distributed to the authority, judges, public prosecutor who really involved in the extradition process. So that's one of the failures as well from the authority part to try to make this knowledge known amongst those who have to implement the law themselves. It's not like this is something they not know, but there's more about the problem about knowledge sharing and this. I think I will end my presentation at this. Yeah, I'm looking forward to any discussion and question. Thank you.
Thank you, Kun Kay. So we're gonna have questions at the back. There's a mic set up there so people can ask questions. If you do have a question, please identify yourself and the organization you represent. One of my big questions right off the top of the discussion is, obviously we wanted to have the Thai government here to discuss this. The Thai government so far doesn't seem to be terribly focused on enforcing this, new law on anti-torture and enforced disappearance. There's been very little movement on enforced disappearance cases. There's been a few cases on torture that have come up. What's your assessment of where the Thai government is on these issues that we're talking about? We were assured, and this is putting on my former Human Rights Watch hat, back in 2023 when there was a new civilian government, that in fact the days of transnational repression were over, that the Pheu Thai party and its government would not do that kind of thing, and yet today we're still having these cases come up.
Yeah, I totally agree to the fact that in the case of enforced disappearance, we have very little progress, but I still want to raise some kind of little hope that they are trying to do something, especially at the prosecutor office, where we engage with them pretty much a lot, especially in the case of Thai nationals who disappeared in neighboring countries, but not limited only to these cases. The case like Qing Bdap or Duawan Thai or other nationals, we also filed petition to them, and they actually start to talk to us, to ask us more about what happened, to summon more witnesses, to provide testimonies, but we still don't know whether they will actually initiate a case. Like as of now, they are saying that we are at the stage of seeking the truth, but we are not actually investigating. So that is not an actual legal case yet, none of it. So yeah, I still think that with the next government and with all your pressure, with all your monitoring, I still hope that they can make some progress on these cases.
For me, if you look back at the history, not very far away, Pheu Thai extradite Uyghur back in a way that is very problematic, and we can see. And now, recently, we see Phumchai Thai extradite Qing Bdap. Not only that, as the Prime Minister, he filed case against many people who are critical of him. Even the Deputy Prime Minister also filing 270 cases of people who are critical of them. These people do not care. And in my experience, international law is no law. It's more like transaction and business. And then you can see Phumchai Thai, I feel like they have the power to become the next government. This human rights thing is not on top of their agenda. If you see how negotiate with the conflict with the Cambodia, this thing is not that important for them. In my opinion, I don't think that we are not going to moving in any positive way. Sorry.
Please go ahead.
I think that There are two aspects to this. I think one is that on the TNR cases, what we really see across, frankly, across the globe, but very much here in the region, is that it immediately becomes about politics and about transactions, as we're hearing. And it really moves away from a procedural, administrative, process of how to deal with cases of pressure from neighboring countries to extradite, etc. And it moves it into a space that is very difficult for human rights advocates to actually influence, and that's because it's political in nature. And there are so many layers of why it's useful for governments to use these tools of transnational repression to get people back, to silence dissent, to keep people from being able to move to other countries. But the other aspect that I think is really disconcerting and seems to be growing globally is that it's not just in the region that this is happening. So you see this transactional in-reach that is really going across the globe. So, somebody from Africa who has been seeking asylum in Canada is finding themselves in difficulties in countries where, it's not a neighboring country anymore. You're talking very far away. And we have actually seen forced abductions from European countries of nationals who are wanted by their governments. And, unfortunately, with things that are happening in other Western countries that are pretty shocking in terms of rule of law, I fear that it could also happen in this transactional nature in countries that otherwise would have been much more difficult to see this. And it really begs the question then, how do we uphold these principles and these laws that member states have committed to? I think there are no easy answers, but I think it really resides in governments globally ensuring that these are part and parcel of trade agreements and other things that actually member states end up caring about, rather than it just remaining in the political sphere where we have very little ability to move it forward and to protect people who need that protection.
So indeed, it's exactly like Cynthia already said. When it comes to political cases, indeed, what we see is we saw the selective application of human rights law and standard. Like sometimes we see that there are some human rights terms that has been used, but selectively on cases, on issues, like including the case of Uyghur, the case of Bdap, that you see like, they try to talk about previous past torture experience, but they disregard the race because when it comes that there's already an answer, but they have to think about justification. That's how you see it happen. So I think one way is that the safeguards are very important, and I talk about the guideline or amending the law, adding those safeguards in, because in Thailand normally authorities are worried about what we call the number that we keep calling is 157, which is when authority doesn't comply with the law themselves, they could be brought to the court. Of course, it's not always happen, but this is one way. Many times in order to reach that point, we need to have something on our hand as well. It's not just something like vague and overboard, like Article 13, in which authority could just interpret it as they wish. And lastly, on guidance on Article 13, I just say that indeed in the past there's not in the past, even now there's an effort to write a guidance on how to apply Anti-Torture and Discipline Act by the national committees. But we are not sure how the final product will look like, because as you know, it's very dependent on political willingness. It's very depends on who the chairperson of the committee, which normally the Minister of Justice, like very depends on how he or she willing to push this forward. because it has been so slow, the process of doing the guidelines. It has been 2 years already since the law adopted, but we still haven't seen much progress on that. And with the election, I'm sure that this will be delayed for at least 5 or 6 more months. You know.
Please go ahead.
Hi, Elaine Pearson from Human Rights Watch. I have a couple of questions. I guess the first one is, I mean, I feel like with the Uyghurs, you can understand the pressure maybe that Thailand would be under, political pressure, economic pressure to send the Uyghurs back because China is a very powerful country. What is the leverage that Vietnam has over Thailand? Like, why is Thailand so keen to please the Vietnamese government in returning Bdap? And then the second question is, I guess, what more can be done now, particularly by third countries, to follow up and ensure that there is, you know, some independent monitoring or a way to actually check on the conditions of those who have been extradited, where we know there is a significant risk of torture? And what is the role, I guess, of third countries in doing that?
Who'd like to take that question?
What leverage the Vietnamese has? I feel like the Thailand way in dealing with all these political cases, they do not want to cross anybody. They do not want to cross China. When China demand that they want Uyghur, they do not want to speak up against it. In the same case with Vietnam, they very strongly advocate. They use the term and the language that we are using. They go to Geneva, sitting through the meeting and trying to say, oh, they learn to use the new language too. This case, they said the act of terrorists. I see this is the rise as well, that there are a lot of people, another country might use this against another activist that even though they not have anything to do with any incident accused of them being involved, and they use that term. That's very strategically used because not only is going to put the picture in the mind of the prosecutor who dealing in this case, because now he is not a refugee, now he is a terrorist. Even though that so-called terrorist, you know, 100 people that been accused, 94 confesses without a lawyer, without a translator, in which the document, the evidence used to accuse him of being a part of it are from those people. I think they are very strategically strong, even though they do not have any leverage against, because Thailand never really have a stand against it. This is why they do not fight for this. And what is the third country should do? Come back is still the same, because his family, right? And he have to resettle. The third country will think, if the family is resettled now, what's going to happen after 10 years? He will have the right to see his family too. Is that something that the third country considering not giving the resettlement to his family? Is this why we are hanging like this for now? You know, so going forward, I don't know, I'm welcome suggestion.
Well, I mean, it would be important to actually find a way for his wife and children to resettle to a third country if possible. Yeah.
Can you help open my slide again? No, I just try to answer the first question. I mean, I'm not the political analysis, so I'm not sure when it comes to politics, but from the legal perspective, I might have the answer to your questions. Can you move to the first slide, please? Just the first one. If you look into there's one interesting thing written in the extradition law. I don't want to accuse that this is going to happen, but if you look at section 9, subparagraph 2, it says if there's no extradition treaty with requesting state, which is in this case, there's no extradition treaty between Thailand and Vietnam. When the extradition is granted to Thailand or to another countries, we expect to have it in the same manner. So that means if this time Thailand extradite someone to Vietnam, in the future, you should also grant our extradition request when we make such a request. So in terms of politics, I'm not sure what kind of pressures, but from the legal perspective, this might be the answer. You first
It's
granted
called
and then you
reciprocity.
yeah.
Right. Yeah, I mean, what's astounding to me was, of course, that he was convicted in a court in absentia when he wasn't in Vietnam when these acts in Dak Lak took place. You know, that all the evidence was basically compelled testimony by people who were in front of a kangaroo court in Vietnam, and somehow that was taken as a credible indication of terrorism. So.
Double dipping.
What?
Can I go again
Yeah.
one more? Not only Vietnam advocate with the Thai government, they also advocate with the third country as well, supporting the document from their point of view to the country that we are working with on the resettlement.
Oh,
So
really?
yes. So the
What-
leverage, like Gay said, the Thai government might have somebody in Vietnam that they wanted, but we cannot confirm that. But we can see there might be some swap that's going on.
Something, yeah.
Cooperation. That's
Right.
the only thing that I can see. Yes.
Right.
Yeah, I also already mentioned that we have 3 people disappeared from Thai nationals from Vietnam, so maybe they have our secrets.
Well, what is quite clear, and this is background information that I know about the case, is that in fact, when the government of Vietnam accused Qing Bdap of being involved in terrorism, they then said that the U.S. was supporting Qing Bdap to do this, and that then froze the U.S. government. They decided at that point that they couldn't resettle him, and they had to try to get somebody else to resettle him, and that didn't work. But you know what you had was a specific allegation against State Department officials, which were, you know, the Vietnam government just made up. So, anyways, the floor is open. Other questions? I guess the question I would have is, do you see that there's real political will within the Thai government to enforce this anti-torture and anti-enforced disappearance law? I mean, it wasn't the law that they really wanted in the first place. It took a long time to convince them to do this. You know, is this a situation where they passed the law and then basically they just sort of put it over to the side and maybe we'll use it now and again? But is there any political will to actually, you know, use it in a significant way? And also, particularly on cases of enforced disappearance, there's dozens of cases of historical enforced disappearances in Thailand that have never been solved.
Very quickly, and may I add, because India, what this is, we have to see the outcome of the election as well, because it depends on who's the Minister of Justice, the next Minister of Justice, because the Minister of Justice will play a very important role in terms of pushing everything forward. Because everyone have to report to the committee, and the chair of the committee is the Minister of Justice. So when the Minister of Justice interested in any issue, we could see that it has been moved pretty fast. But if there's something that they raise interested in, things were pretty slow. You know. So the result of the election will tell many things. And at the authority level, justice sector actor level, it's pretty dependent. I mean, of course, if you ask someone whose KPI is to implement this law, I mean, in Thailand, KPI is how you grade the performance. Of course, they're viewing too. You know. But the KPI of most of the justice sector actor has nothing to do with this.
From my opinion, not political view to enforce, a political view not to set a standard. Like, because this is the first case, I almost feel that in the language the prosecutor said in court, you know, they said, then it means the refugee can do no wrong. They can commit a crime, and then when somebody trying to extradite them, then they can say, I cannot go back to my original country because I might face, you know, torture or extortion. Despite the fact that we have the Commission from Human Rights testify that only it never mean they not be prosecuted or punished. It only means that they cannot be sent back to their original country so long as that the threat is still there. But it seems they did not hear it. But I can see most of the case when we are trying to push the international standard, they are very defensive. You can see in the language that they use in court. Don't want to be the first case.
Don't want to be the first case.
Yes.
For me, who engage with this law a lot, with our lawyers as well, we encountered a lot of problems in terms of the interpretation of certain words. Like, for example, this is not considered the enforced disappearance under its definition in the law because they found the face already, or they are trying to say that it's not Thai state officials who does this. But we didn't have any provision saying that it should be just Thai officials. In my opinion, that it should cover anyone who are forcing someone to disappear in our country. And as I said, that when we filed petition to all the institutions relevant to the prevention of torture, all of them are like saying something that it's not my power to do this, you should go to the Attorney General in states, and then some others saying that I don't know anything, I don't know what to do, things like that. So there are a lot of obstacles during the whole journey, so yeah.
Yeah, please. It sounds like a lot of people passing the buck.
I think that what we see certainly in other countries is that the implementation of laws that are dealing with such incredibly sensitive matters and on accountability, I mean, let's put aside Mr. Bdap's case for now, but talking more broadly about the issue of torture and enforced disappearance, I think it really requires, and this is where we've seen countries really turn the corner, it requires extremely consistent political courage by a leader to say that no matter what, we will move ahead to process and prosecute cases of torture and enforced disappearance, even when they're taking political risks to do so. And so I think sometimes it takes some time to get there. We have seen a few, as you mentioned earlier, Phil, a few cases of torture that were quite important with the military. But I think they need to now really push forward in a very, very significant way. And the issue of Mr. Bdap is such an emblematic case because it really points to that political will to do the right thing under this legislation domestically, and of course under the mounting sort of obligations that they have now that they've also acceded to a new treaty, which is new for them, which was on enforced disappearances in May of 2024. So I think we need to see some very courageous leadership come forward if we're going to turn the corner in Thailand on holding people to account for laws, whatever they may be, but particularly when it's so sensitive like torture and enforced disappearance that cuts to the core and the heart of the state.
Okay. Any other questions? If not, I'm going to end it there, but I will note that when we talk about courage in the face of daunting odds, I will note that today, December 15th, marks the 13th anniversary of the enforced disappearance of Sombat Somphon, the Lao civil society leader who was disappeared at a police checkpoint in Vientiane in Laos. Has never been seen since. This was a man who was a Magsaysay award winner, a leader of a generation, and it disappeared without a trace 13 years ago. So obviously in the region there's still a lot that needs to be done to deal with these issues of torture and forced disappearance. Qing Bdap himself, there's still no confirmation of where he is. There's no confirmation of when he was sent back. The fact that civil society advocates have to consider petitioning the Senate and the House of Representatives in Thailand to get basic information about like on what flight, at what time was he sent back on the 28th of November, strikes me as rather absurd. So, I mean, obviously, there's a long road to go in effective implementation of these laws. These are the folks who are trying to do it. I thank you for coming. I wish the Thai government had come to explain what they were doing, but they are obviously busy doing something else. So with that, I will conclude the program. I will say also that on Wednesday, Wednesday evening this week, on the 17th of December, we'll have an event at 7 p.m. Talking about the election in Burma. So if you're interested in the situation, what's going on in Burma, please come to that on that evening, 7 p.m. Again, thank you very much to the panelists. Thank you all for coming. And obviously, they'll stay behind afterwards if you have any questions you want to ask them directly. So thank you very much.
Thank you.